Greetings, my fellow Americans, and welcome to another episode of the Great Montana Conspiracy Podcast. Tonight we're going to be talking about Brady Lists. Now, Brady Lists stem from an actual U.S. Supreme Court case called Brady v. Maryland, a 1963 case, which I'll go into in just a moment. But I want to make it very clear at the outset that Brady Lists are not necessarily a standard of law, they're a practice of law, which means it's a standard routine thing that police stations and states across the country have employed to try to kind of offset the requirements the courts have set down for them. A Brady List basically is a collection of officers who have committed crimes or done something inappropriate, ethically or otherwise, and which may affect the credibility of the officer's testimony. Now, interestingly enough, we have a problem in Montana. Big surprise, and even much bigger problem in Flathead County. And I'll get into that in great detail as we proceed. But first, let's talk about Brady versus Maryland. This is a landmark decision. It's Brady law. It's like one of the cornerstones of prosecution and criminal defense. It established the idea that prosecutors are required to turn over any evidence that might be exculpatory and help exonerate a defendant. Very common sense by today's standards, but before 1963, it wasn't a requirement. Prosecutors could withhold and only provide whatever they wanted to provide. They didn't have to make any decisions about, oh, this might be good for the defendant. They could actually deliberately withhold evidence that actually could prove the defendant didn't do something. You know, if they knew the defendant was innocent, they could withhold proof that he was innocent until this case. Now, basically, I'll give a brief background on the case. It's pretty straightforward. On June 27th, 1958, John Leo Brady and Donald Boblet, I hope I'm saying his name right. If anybody out there catches me on it, by all means, fix me and correct me, and I'll post a redaction later on. They murdered an acquaintance by the name of William Brooks. Brady confessed to being involved, but he insisted that Boblet was the one who committed the actual murder. Now, separately, Boblet did in fact confess to committing the murder himself. He said Brady wasn't involved. So the defendants were tried separately, but Boblet's confession was actually withheld by the prosecutors from Brady's case. So Brady didn't have the advantage of any evidence that proved he didn't actually commit the crime. He was just an accomplice, essentially. The defendants, because they were tried separately, Brady was not even aware of Boblet's testimony until Boblet's own information became public. Brady was given the death sentence for committing a heinous murder. Now, the U.S. Supreme Court came back and said, nope, can't do that. Absolutely no way. No, prosecutors must disclose any evidence that may or may not. It's basically up to the defense to decide if it's exculpatory. Exculpatory, of course, means whether it can prove someone's innocence. If you can exonerate somebody, it is up to the defense to decide if that is possible. It's not a place for the prosecutors to withhold information that may or may not be favorable just because they don't want to share it. They must, and now pretty much anything can be taken as exculpatory or potentially exculpatory. So it's really safe practice to simply just turn over all evidence you have rather than sit here and try to figure out which one may or may not be interpreted as exonerating. Makes sense, right? Welcome to Montana. Just as a general oversight, Brady did, in fact, go back for resentencing. He was resentenced to life in prison as opposed to the death penalty. And he was actually later paroled, went on to live a normal life, created a family in Florida. I don't know if he's still alive today, but by last report, he's never reoffended. He's never done anything else again, and he's lived as a law-abiding citizen going forward. But he could have been dead. He could have been murdered by the state because the prosecutor didn't want to turn over a confession that he didn't actually commit the crime. So it was a huge issue. And this is a case where the United States Supreme Court absolutely got it right. And this is a case that just affects everything when it comes to criminal defense. States, as a consequence, they try to, the ones who actually care about this, I gotta emphasize that, the ones who actually care and want to allow for the enforcement of these issues have created what are called the Brady Lists. And Brady lists, you would think this would be, by now, by today's technology, this would be a national thing. And there has been some effort to create national Brady lists by independent nonprofits. But no government agency has ever done so. Officers who have committed crimes, ethical violations, or anything that affects their credibility end up on these lists. States typically maintain these databases of offenders and then make them available to anybody who needs them, whether it be defense attorneys, prosecutors, whatever. Montana has no such database. Does not exist. Basically, it falls down to the counties. The really bad part, though, and this affects nationally, not just Montana, police departments have basically gained the ability to control what information they turn over to whatever services acting as a repository for this information. They decide if their officers have committed crimes, ethical issues, or whatever, and voluntarily turn them over. There's no mandatory requirement that they report this. There's no law. There's nothing that says that an officer who has been cited for behavior misconduct, who's committed an ethical issue, anything must be turned over to these Brady. It's a completely voluntary cooperative issue. That's why I said this is a procedural issue more than a legal issue. It obviously it saves a lot of time when you know in advance whether or not officers have actually had prior issues of credibility. I mean, it can affect a huge issue. If a black man is being tried, and no offense meant by the term black, by the way, African American or whatever term you deem appropriate, is being tried by an officer who has a history of racial slurs and racial violence, you need to know that when you're going in and defending this person, or when you're defending yourself if you're a pro se litigant. You need to know that an officer has a prior history of racial bias and bigotry. I mean, that's just a main red flag. But if the officer has a history of being dishonest, or has a history of being problematic behaviorally or whatever, these are all issues that can affect significantly how a defense proceeds upon whether or not the defendant can be exonerated of the crime of which he's accused. What was a problem in other states is a horrific crisis in Montana. Because, as I said, there's no statewide maintenance system. Several counties in the state, several county attorneys' offices, who this has pretty much fallen to is the county attorney's offices, they actually maintain an electronic filing system where they check off and flag officers that have been reported as having issues. Missoula County, Gallatin County are both counties in the state which actually have done so. Flathead County has no such system. In fact, according to just this year, and you're going to love this, there's only one officer. There's only one officer who actually is listed in anything in the county attorney's office for any bad behavior or anything. One officer in the history of Flathead County. In the history, 100 plus year history of Flathead County, one officer. One officer has the ignominious dignity of being the only person on the list. And it stems from a 2020 case. It's recent, folks. This isn't like, oh, it happened back in 87 and he's still on the list. This just happened. They just put their first person on the list. They just did it. Okay. And this is, okay. The officer's name, by the way, is Deputy County Sheriff Matt Vander Ark. And the case that's at issue is Kalispell versus Kelvin Russell Pandini. And for anyone who wants to know the reference number, it's TK 2020-855. So that's TK-2020-855. It's a local reference number. Kalispell does not put their cases online. Therefore, if you want the case, you're probably going to have to go down and actually request the documents from the courthouse or make a information request for it. But regardless of the circumstances, this issue is a big issue because it affects the idea that there's one officer in one case who has an issue, and even he was sheltered. Now, before I proceed further, I need to make a full disclosure. The presiding judge over this case is Lori Adams. She is the presiding municipal court justice in Kalispell. Lori Adams was the lead prosecutor in my case, and she was the main prosecutor for sex offenses. Okay? Just to be clear, and this will affect things in a minute, her only job was prosecuting sex offenses. Therefore, she was the one to go to when it came to anyone being prosecuted for a sex offense. It was basically a caseload that got shifted around from various people, just like in the probation office. The supervision of sex offenders are shifted; they're not scattered around amongst all the officers. It's one caseload, and it's shifted as kind of a, well, this is your responsibility this year or next year for a couple of years, then we'll shift it to somebody else, then we'll shift it to somebody else. It's the least desired caseload that exists. Lori Adams loved it. She just absolutely adored it because, and pardon me if I seem at all offensive, her reputation is, quite frankly, a lesbian man-hater. And I don't say lesbian in a bad way. I have many friends who are both bisexual and gay. It's not an issue about the sexuality. It's the fact that she just hates men, and her sexuality is a very clear element in how and where her hatred comes from. I've witnessed it. I've seen it. I've heard so many stories about it. I'm only reporting it here as rumor, but it is backed up over and over and over and over and over again. Take it for what it is. But again, not intended to be offensive against anyone who is gay or lesbian or bisexual or transsexual. I'm a very big supporter of the LGBT community. Not an issue. But I just want to make sure that everyone understands that this is her background and her history and what her reputation is. But that's why she reveled in the sex offense cases, because 99% of them were men. You very rarely have a female sex offense prosecuted in Flathead County. She got a chance to run at men and just tear men apart. This was her job. She loved it. She reveled in it. But this is the problem. Adams was also the one who walked fake documents into the court clerk's office at 4:33 in the morning, and then at 4:44, and stayed in the office for at least 11 minutes, because at 4:44 in the morning she turned around and issued a fake warrant for my arrest. These papers were never seen by a judge, never considered, never anything. She went in because there was no lock or no way to bar her from the building. She had access to the building at all hours of the day and night, the court clerk's office day in, and she filed these documents so early in the morning before anybody was there so that nobody would even know. And then sent these fake documents to Washington to stop me from coming back to Montana, to terrorize me and threaten me that if I came back to Montana believing there was an actual prosecution. She then kept these documents on her desk until the following Tuesday, after she found out, oh, guess what? Even though I wrote the warrant to be only to officers in Montana, Washington Sheriff's Department acted on it because I sent it to them, or she sent it to them, and they acted on it. They arrested me under it. Well, now they had me arrested. She had to actually file the documents. At that point, she walked them into the courtroom and filed, or courthouse and filed them. The only thing she had in that docket until the following Tuesday was a placeholder document for the case number. That was it. I was arrested and detained on a warrant that wasn't even filed with the court in the court clerk's office until 4 days after my arrest, and Lori Adams was the one who did that. This woman is not a good person. She is very much a part of the Good Old Boy Network, and she is a criminal operating in office. Adams was involved, but just to give you an idea of how protected and sheltered she is by the system, she was involved in a rollover drunk driving case. I want to say it was 2004. It was 2004 or 2005, because it was while I was in Flathead County Jail. Now, mind you, reputation and rumor is that she's pulled over all the time and never charged. She's a judge. Judges never get charged. Stuart Stadler was a big one for this. He'd get picked up, brought into the sheriff's office, wait for somebody to come pick him up. Lori Adams was never prosecuted for any of her DUIs. The only reason why this issue even came up and became public was because she rolled her car. She rolled it across the lane of traffic, ended up upside down, but she was never charged for it. Her only penalty was she could not prosecute DUIs for a year. Remember, she's not even on a DUI caseload. She is the primary sex offense prosecutor. This wasn't even a penalty. This would be like having a dentist and saying, okay, your penalty is you can't do brain surgery for a year. The dentist doesn't do brain surgery. So how is that a penalty? Good old boy network protecting their own. I have personally seen Adams walk out of a convenience store with 2 big 30-can cases of beer, put them in her truck and drive away. The woman is a prolific drunk by both reputation and witnessing it. And again, the only reason why she wasn't prosecuted was because, or the only reason why she wasn't just overlooked or even cited for the rollover was because it was a rollover. If she had just been pulled over, it would have been swept under the rug. The physical damage that was caused required some kind of reporting. And the report was, we're just going to slap her on the wrist. And here's another issue. And by the way, I will attach a copy. I took a picture of this. We just had our elections here in Flathead County. It was a big joke. We had 2 council members and a judge position. Guess whose judge position it was? It was Lori Adams. I reported previously that no one runs against these judges. No one runs against the judges. No one runs against the court clerk. No one runs against the county attorney. Because to do so is political suicide. And here we are. I have a photocopy of my own ballot. Now, keep in mind, you'll see on the ballot, whenever I don't agree with any existing official, I write a protest vote. I write my own name in. I've professed this for years now. If I don't like a candidate, or I don't know the candidate, or I don't trust the candidate, I write my own name as a protest vote. I did it for both council members. I did it for Lori Adams' position. Only because I don't trust these people. Nobody has ever demonstrated to me that they actually care. I've actually tried to talk to some of the city council members, and they shove it under the rug. They don't care. Nobody cares, and until I get somebody who actually cares about this, I'm not going to back them. I'm not going to vote for them. I will write my name in as protest, and I encourage anyone else who wants to protest in Montana to do so. I can't hold office. You're not electing me to office. So long as I'm a felon, I can't hold an office in Montana. So you're just voting for someone who can't even take the position. You're just protesting. So there you go. Do it if you want. It's a great way to show you protest and you back this podcast and you back everything I'm about. But once again, this is why I'm bringing this up, because I do have a history with Lori Adams. I do know a lot about Lori Adams, and therefore one thing that's going to come up is rather peculiar for her behavior and her conduct. I don't quite know the reason for it, but I will explain that as I come up to it. But it is important to know this is not attacking her in the regards that you know my full history with her, you know my background, you know what I think of her. This is not why I'm addressing this case. I'm addressing this case because we have a police officer who's the only police officer, and it just happens to be her case. And something that she did instigated this. So, here we go. Once again, the case is Kalispell versus Pardina. Kelvin Russell Pardina was facing reckless driving charges. 2 officers responded to the scene when he was pulled over. KPD Officer Brenton and Flathead County Sheriff's Officer Matt Vander Ark. Now, Vander Ark's had both his vehicle, the Flathead County Sheriff's Office has both in-car cameras and body cams. Okay, so when the defense got the discovery packet, there was no body camera in-car camera evidence submitted. So the immediate question came up to, why wasn't it submitted? This is a Brady violation. There's obviously evidence. It was not turned over. It could potentially be exculpatory. We don't know because we don't know what's on the footage, but you need to turn it over. Vander Ark offered 3 different excuses for why this information was not provided. His first story was that when he pulled up mind you, he was the supporting officer. It was the KPD. He pulled up as a supporting secondary officer, and that's largely what he hides behind throughout the entire process, and actually what Adams uses to clear him of any actual wrongdoing in the case. But he pulls up behind the KPD Officer Britton's car and proceeds to assist with the arrest. His first story for the reason why his in-car camera was not working is that he says his lights were not on, and his lights would trigger only, or his in-car camera would only turn on if the lights are on. So that's why he claimed there was no in-car camera footage. He also said he had no body cam. Had no body cam, had no in-car camera. That's why they weren't turned over. Well, Officer Britton's footage actually showed that Vander Ark's lights were on, and it physically showed him having the body cam on his uniform. It by all intents and purposes, impeached the sworn statement of Deputy Vander Ark. So Vander Ark comes up with a new statement. He says, well, actually, I was only there because I was a backup. The light was on, yes. The in-car camera was on, yes. But because I was only a backup, the camera footage wasn't saved. It was recorded over. And my body cam was damaged because I was involved in a foot chase a couple days earlier and it was damaged. Well, that didn't hold up for very long because he turned around and changed his story a third time and testified that his body camera was working fine. It just wasn't on. Now, anybody see a problem here? Why is he spending so much time trying to have an excuse for not turning over this body cam footage? Well, there was a conversation that Officer Britton showed that Vander Ark and the defendant had on camera by Britton's, but the audio was not able to be picked up. It would have been picked up on the body cam of Vander Ark. The defense's position is that something in that conversation could potentially have exonerated their client. I mean, if you have a case to where potentially a conversation with the officer and something was said, you want to know what that was said. You want to know what that officer said. You want to know what was going on. You want to have all this information should be available to the defense. There could be something exculpatory. There could be something in there which would have exonerated Pandina. But Vander Ark deliberately told 3 different versions of the story so he wouldn't have to produce it. Adams, of course, ruled that there was no Brady violation. She said, in spite of the fact there was clear evidence that the recordings of Vander Ark could have contained exculpatory evidence because nobody knew what the videos actually contained. In spite of the clear violation of not turning this information over and having destroyed it, she actually ruled that because there was no proof that the video contained exculpatory evidence, it wasn't a Brady violation. How can you prove whether it existed or not if you don't have the tape? How do you prove if an audio tape or a videotape has information if you can't produce the videotape? It's hearsay. She says, oh, he can testify to whatever he wants to in court. Well, we've already established that Vander Ark is not a credible witness. Therefore, Vander Ark, they'll bring him back for if Pandini tries to testify at his own hearing as to what conversation he had with Vander Ark. Vander Ark's going to come back, and are you going to believe him? He wasn't cited. He wasn't given a contempt charge. He wasn't given anything. Now, this is where it gets really interesting. In a very rare move, and I'm not sure what inspired this, whether somebody has some kind of leverage over Lori Adams, or whether Vander Ark maybe upset somebody in the chain of command, and he was being taught a lesson, which is what Good Old Boy Network does. If you step out of line just a little bit, we're going to slap your hand. Remember what happened with Lori Adams? We're going to slap your hand and make it public that you had this rollover, but we're not going to really do anything serious to you. We're just going to say you can't prosecute DUIs for a year. It has no actual impact on you, but we're going to make a note of it just to show you that we don't like being embarrassed this way. So maybe Vander Ark did something that stepped on someone's toes. Maybe someone had leverage over Lori Adams. Whatever. Lori Adams did the one thing you never see any Flathead official do. She actually wrote a complaint, or more appropriately, a summary of why Vander Ark's testimony was not admissible, why it wasn't credible. And I'm actually going to read you the letter because I have it right here in front of me. Ironically enough, it was released by the news media, by NBC Montana, by the way. Thank you, NBC Montana, for your straightforward reporting on this, because this is a fantastic resource to have. I'm glad you revealed it for us. But here's the letter. It's addressed to Sheriff Hino. It says, "This letter is to advise you that in the above captioned matter, Deputy Matthew Vander Ark has provided 2 sworn affidavits and sworn testimony at a Brady violation hearing in the Kalispell Municipal Court. The 3 statements contradict each other, and the court is unable to reconcile the statements. Therefore, the court deemed Deputy Vander Ark's testimony to not be credible in this case. The court has attached the findings of fact, and conclusions of law in this matter for your records. Regards, Lori Adams, Kalispell Municipal Court Judge." The interesting part about this letter is that it was CC'd to Deputy Matthew Vander Ark. It was CC'd to Charlie Harble, the Kalispell City Attorney's Office, and Larissa Anderson, also in the Kalispell, who was a Kalispell Assistant City Attorney. Trevor R. Honor, AHNER, by the way, he's the county attorney, and to Doug Overman, the Kalispell Chief of Police. Now, whether because of this particular letter or a separate report that was made, the city attorney and the county attorney both were asked to consider whether to press charges against Vander Ark for perjury. So, what do you folks think happened? Should we do like a Jeopardy minute here where we ask whether or not, and ask what you think? The answer is obvious. He wasn't prosecuted. He wasn't prosecuted. It was sent up to the state level, which is the Montana Public Safety Officer Standard and Training Council, which stands for POST, P-O-S-T, if you ever see it abbreviated. They declined to charge him. So nothing ever happened of it. The only unusual thing, and the only reason why this raised red flags, and the only reason why Deputy Vander Ark became the only person on a Brady list in Flathead County, was because, for some reason, Lori Adams wrote a letter that became public. And that public disclosure put Vander Ark as the only person ever on the Flathead County Brady list. I mean, this is, Adams' irregular conduct aside, this is just a huge example of how the good old boy system works in Montana. It shows how entrenched it is, and just it highlights it. I mean, clearly Vander Ark's in-car and or body camera footage were relevant. They existed. They should have been turned over. Clearly Brady law required that they be turned over. They were not. Either they were erased or they were simply withheld. Either way, it was a clear and flagrant Brady violation. Lori Adams defended in court the lack of footage. She defended Vander Ark in court. She said that Vander Ark's testimony was immaterial because Officer Britton's cameras showed the arrest and showed everything that was appropriate and needed for the prosecution. Not for the defense, for the prosecution. She could have charged Vander Ark with contempt. She could have actually written a letter that said, "I am hereby sending a recommendation to charge you with perjury." The best I can tell is the only thing she did was she CC'd this information to the city and county attorney's offices. Neither the city nor county attorney prosecuted this case. Clear, flagrant perjury. The officer was clearly covering something up. We'll never know because it didn't go beyond this. The state level, POST, did not recommend being charged. Every stage of this was rigged. And if you can't see that, I don't know how to make it more flagrant. Deputy Vander Ark clearly had access to information that was required to be turned over to the defense. For whatever reason, the county sheriff's office did not do so. The county attorney, or the city attorney in this case, because it was a municipal court issue, the city attorney did not turn this over. The defense recognized the problem. The defense recognized the absence of evidence, and after it was demanded and realized there was none, that the city attorney was not going to turn it over, they filed for a dismissal under a Brady violation. But Adams protected it, even though she sent this letter summarizing a problem with his testimony, which interprets basically to this man committed perjury. Despite that, he was not charged by the city attorney, he was not charged by the county attorney, and even the state level post would not get involved. Worst of all, he's the only reported police or sheriff violation in the history of Flathead County. The only one. Vander Ark was even on administrative leave for an officer-involved shooting when he was first interviewed. He was involved in an officer-involved shooting, yet somehow that information doesn't show up on a Brady list. With massive history of corruption in this county, not just reported by me, but I've put links up to other issues as well, no officer has ever been charged with anything, ever. No officer has ever done anything wrong, ever, in all of Flathead County or Kalispell. It's physically impossible, ladies and gentlemen. It's simply not human nature. You cannot tell me that every single officer, every single deputy that's ever been hired is the most upstanding, perfect person you've ever imagined, and they are robots. They do nothing wrong. It's not possible. And yet somehow we have one officer on the Flathead County Brady list. We have no, and he wasn't even prosecuted. He was not prosecuted at any level. Just reported. Remember, Kalispell has no internal affairs department, no independent oversight, either for the sheriff's office or the Kalispell Police Department. When police get to govern themselves and control what they report, because remember, this is a completely voluntary system. There's no criteria what they have to report, when they have to report, or even if they have to report. It's no surprise that they choose not to report at all. Welcome again to the Great Montana Conspiracy. As always, if you like these videos, please like and share, like and subscribe, as the terminology is on YouTube. If you're watching this on YouTube, or please follow my channel, please like the videos. If you're seeing this somewhere else, and for some reason the text is not attached to this video, because by all means you should be seeing the text attached to this video, especially since I'm going to provide a link to an uploaded image so you guys can see what the actual ballot looks like here in Flathead County, and to prove that these people have no one ever run against them. You're going to want to go to monspiracy.podbean.com if you don't want to go to YouTube and look for the Great Montana Conspiracy podcast, where the text will definitely be. As always, if you're watching this video, please remember, be safe, and whenever possible, please be free. Thank you.